Good morning and welcome to day 4 of the Insolvency Conference. We've got two fabulous talks coming up for you today. First of all, Ali Tabari will be talking about administration, light touch administration, pre-pack sales, and the topic that never goes away, defective appointments. Then Raghav Trivedi will be talking to you about 3 new cases on directors' liability. A reminder about our panel discussion tomorrow at the same time, 9:30, but you need to sign up on the website for a separate Zoom link. This will be an opportunity for you to ask questions and to contribute to the discussion as we discuss recent topics in administration, in insolvency law, including, of course, yesterday's news that the moratorium on winding up petitions has been extended until the end of June. Now, Ali Tabari, administration, changes and future trends.
Thank you very much, Rob. Good morning, everyone. If we were running this in the ordinary course of things, this would be very much the graveyard slot. Some people already heading for the door, catching up on emails, other people looking forward to the pub, what I wouldn't give for a bit of pub right now, even though it's 9:30. So thank you for seeing us through to the end of this insolvency week. My talk is going to deal with a few changes which are likely to affect how administrations are run this year, specifically pre-packs, light touch administrations, and finally, as Rob said, the never-ending saga of the defective out-of-court appointment. But before we find out where we're going, it's good to find out where we've come from. So what I'm going to do is I'm going to share screen and fingers crossed that the tech works. There we go. So far, so good. So these are the topics we're going to deal with. 2020's performance then. Well, it's going to be no surprise to anyone that in 2020, the number of corporate insolvencies underwent quite a significant drop, and administrations were no different, as you'll see from this table. Quarters 3 and 4 of last year saw the number of administration appointments drop 31 and 27% respectively in comparison to those same quarters in 2019. Overall for the year, not quite as much of a drop, but 16% nevertheless, pretty significant stuff. So I suppose the two questions that come from that are why the drop, but also the other side of the same coin, why wasn't the drop even worse given the devastation that's been caused to the economy by COVID? Well, most of you will already know the answers to those questions. First of all, there's been a restriction, as we know, on the use of statutory demands and threats of winding up petitions, which would usually be the kind of alarm bells for a director to pick up the phone and get some proper insolvency advice. The same goes for the backlog in court cases. I think this is actually real footage from Birmingham County Court's listing office at the moment. If cases aren't being processed, then the companies aren't being hit with liabilities or potential liabilities, which again would make them reach for the phone. Then, of course, we have the government's support that's been provided to a number of businesses who, had it not been for that support, would have found themselves in some kind of insolvency process. But again, the flip side of that same thing is, whereas there's plenty of deserving businesses, if you can put it that way, who've received a lifeline this year, that same government help has assisted in propping up what we call the zombie companies. Those companies that just survive from year to year without ever needing to thrive. There's low interest rates, and so they can just plod on regardless. I think the conventional wisdom from business analysts is that you do need, as part of a healthy economy, these zombie companies to be put to one side, put out of their misery, so that, for example, their workforce can be reskilled elsewhere, there's space opening up in the high streets and so on. It's all part of the natural churn. So once the safety net is removed by the government, there'll be a spike in corporate insolvencies towards the end of this year and well into 2022, which of course is going to include administrations. So I'm going to talk to you about pre-packs. And of course, it's a topical thing to discuss because we only had the draft rules confirmed into the new actual rules, which are going to come into play in a month, just a few days ago. Now, LinkedIn is not just about inspirational quotes and people humble bragging about some award that they've won. It's fair to say that these new rules haven't exactly been welcomed by the insolvency community with open arms. And I saw something from an IP, and I'd love to be able to name who it was, but I'm afraid I can't remember, on LinkedIn, which said this. You might be wondering what on earth Eddie Murphy's got to do with pre-packs. Well, hopefully it will become clear in just a moment. This IP said, over the weekend, I had the choice of either reading the new rules on pre-packs or watching Coming to America, the sequel to the classic 80s comedy. My choice turned out to be, in the main, a poorly scripted mess without any real thought for how it will really impact its true audience in today's day and age. That having been said, it was hilarious in its absurdity, so far-fetched, you had to just accept that the writers, who are obviously comedy writers, meant it to be played out as a complete farce. I think we all know what the punchline is going to be. Now that's done, I intend to watch Coming to America next weekend. Well, there we go. So not a great start on these new rules for pre-packs, but why do we even need new rules for pre-pack sales to connected parties anyway? Well, of course, there's a perception, isn't there, that pre-pack sales to connected parties are just a cozy stitch-up. They don't provide best value for the creditors because the connections are just too close and not scrutinized properly. And often creditors are left high and dry, and those same people who've driven the company into the ground pick it back up in its new form for a song and just carry on where they were. But of course, on the other side, there is a perfectly good argument to say that connected parties are usually the best and often the only viable purchasers. And pre-packs done properly will save jobs and they will rescue businesses as going concerns, which of course is the whole point of an admin. But what comes with that is a great deal of time pressure. And that's really where the pinch point for these new rules comes in. Now, there's something called the pre-pack pool, an independent body of business people for an opinion on whether the terms of sale are reasonable. It was established in 2015 at £950 plus VAT. And it's a voluntary process with non-binding opinions given to the administrators to say whether or not they should go through with that transaction. But as of 2019, only 8% of connected party pre-packs use this pool. And I don't know who amongst you has actually used this and whether you found it to be useful. Of the IPs who were consulted for the government's recent review, the Graham review, as they call it, the most popular answer for not using that pool was that there was no perceived benefit in doing so. And in fact, they didn't need to use the pool, and so they didn't. So what we've got now is the very snappily titled administration brackets, restrictions on disposals, etc. to connected persons, close brackets, regulations 2021. The regulations are short, and so this is going to be a whistle-stop tour. The regulations aren't the clearest, but at least they are short. It certainly takes less time to read them than it does to watch any Eddie Murphy movie. So you'll be able to find those online, but we'll point you in the right direction here. It's important to note that these rules come into force for administrations which commence on or after the 30th of April 2021. So please do mark that in red on your calendars. So what do these new rules say? Well, what they do is they prohibit a transaction that fulfills three criteria. The first is that it's a disposal of all or a substantial part of the company's business or asset. That's a call for the IP to make. There's no guidance on what those words mean. That transaction needs to be made to a connected person, and it has a specific definition. It points you in the right direction, which is paragraph 60A sub 3 in Schedule B1. It's all the usual definitions that you'd expect to mean connected persons, a director, shadow director, their relatives, that type of thing. And it's a transaction which is taking place within the first 8 weeks of an administration. This is potentially really where the difficulty comes in, because of course this is probably going to affect pretty much every pre-pack connected party sale. And you tend to line these things up before you take the appointment or very, very shortly afterwards. Generally speaking, if something needs a pre-pack, in my experience, you don't really have 8 weeks to sit around. So one way or another, these rules are going to hit the vast majority of those pre-packs. So that transaction is prohibited unless one of two things happens. The first is that you obtain creditor approval, or the second is that you obtain a qualifying opinion. And we'll go on to see what each of those things means in just a moment. Creditor approval does what it says on the tin. It requires the administrator to include the proposal for sale in their paragraph 49 statement of proposals, and there needs to be a qualifying decision-making procedure undertaken and there's a sufficient majority of the unsecured creditors, and there we are, the transaction goes through. But for any company, I would have thought that's more than a small SME, you might have more than just a handful of creditors. And of course, the time it takes to track all of those creditors down, work out if they're opting in or opting out, set up a qualifying decision-making procedure, and then going through it. And then, of course, there might be modifications to the proposal. You're probably going to lose a lot of the impetus for making that pre-pack sale in the first place. The goodwill will have dissipated, the momentum will have gone. It might be that redundancies or other job losses are inevitable if you leave it too long. So query whether we're really going to be going down the creditor approval route too frequently. But of course, if you do get it, well, that's the end of the matter. You've complied with those rules, and Bob's your uncle, and on you move. But if you don't get your creditor approval, then the second way which you can put one of those transactions through is by getting a qualifying report. Now, here's where some of the fun comes in. The qualifying report is a report which has to be obtained by the connected person, not by the IP. And the author of that report must be satisfied that their relevant knowledge and experience is sufficient for the purposes of making a qualifying report. There is no guidance in the regulations, or indeed anywhere else, as to what any of these words mean. So it's a self-certification process. A person is an expert if they consider themselves to be an expert. They also have to be insured to give that opinion. So perhaps that adds a little counterweight to the potential that anyone could just turn up and say, I'm qualified to give that report. And what does the report say? Well, the report has to, in the end, give an opinion on the proposed sale and the proposed sale price or other consideration that's being paid. It's not a qualifying report if it doesn't give that opinion one way or another. The author of the report, of course, has to be independent. And there's a whole heap of definitions as to what that independence means. They have to be not connected to the company. They have to be not connected to the administrator or the administrator's company, or to the connected person themselves. They don't have an identifiable conflict of interest. But then there's also this 12-month rule, because they must also not have given an opinion to the company or the connected person, and these are the words, in connection with or anticipation of the commencement of an insolvency procedure, or in relation to corporate rescue or restructuring in the past 12 months. So if a company director has gone to the lengths of going to an IP, getting some kind of valuation, and then sometime later on the insolvency process kicks in, they can't then use that same person to give the qualifying report if what they want to do is make a connected party pre-pack sale. So what's this going to lead to? Is it going to lead to, for example, groups, cartels of insolvency practitioners and suitably qualified experts simply passing the work to one another in some kind of informal carousel? Who knows, to the extent that doesn't already happen. But it's just one additional layer of complication to add, because of course, the moment you slip up on something like independence, it's no longer a qualifying report. And that sale may not necessarily be upheld. But the final interesting point about this is that if the connected person has already obtained what they would like to call a qualifying report, then that has to be disclosed to an author, basically to stop connected persons from going around and shopping for authors who are prepared to give them the right answer and tell them that their price is okay. And again, there's a whole very specific list of steps for the court to take and for the author of the report to take if they know or suspect that they're being lied to about that particular point. So it's worth a read. It's not the easiest to follow. So what then happens once you've got the report? Well, it's sent to the administrator, and the administrator then has to send it on to the creditors and to Companies House. But here's the interesting thing about it. The administrator doesn't actually have to follow the recommendation of the qualifying report. If they don't, they'll have to give a written justification for acting against that opinion. So what's this doing? It's making it certainly look as though creditors are getting a fairer deal, because there's an additional layer of oversight that perhaps wasn't there before, or at least was there, but was only voluntary. Potential is what it's going to do is it's going to add time and cost to a process that, generally speaking, can't really afford that. Whereas the pool, for example, was capped at £950 plus VAT for a report. There's no such cap here. People can charge what they want. Presumably, it will just be market forces that determine whether or not this is something which works, or whether it leads to pre-pack sales being stuck in the mud. And it might be one of those that has the unintended consequences of actually preventing jobs being saved and companies continuing as a going concern. But one thing's for sure, though, you'd be better off spending this weekend reading the regulations than watching Coming to America, which is meant to be not very good at all. I'm going to move on now and talk about light touch administrations. The LTA it's nothing new. It's actually been sat there unheralded in the Insolvency Act for some time, but it's not an option that's been taken up very much at all. So perhaps now might be the time to see if it's going to help in certain cases. I think it's fair to say the public don't really think too much about rescue culture when they hear the word administration. Everything you see on the news is company XYZ has collapsed into administration, but it overlooks the fact that the first statutory purpose is to rescue a business as a going concern, and that's where LTAs might well play a part. Now, as we can see here from paragraph 64 of Schedule B1, it says that no director of a company in admin can exercise a management power without the consent of the administrator. And as we know, the consent of the administrator, generally speaking, is none. But why shouldn't the administrator afford at least a little bit of influence to the people who, after all, know about how the company is run? The basic premise of an LTA is that whilst it's an administration, just like any other, the existing management team or parts of it are retained within the business. They're overseen by the office holder, but otherwise they just get on with running the business as they were before. I read an interesting article by a couple of gents from FRP, Jeff Rowley and Phil Reynolds, and they said that an LTA is a bit like watching a car crash take place. And then you go over and give the keys back to the driver and say, well, have another go at getting yourself home. But the point about LTAs is that, of course, while some car crashes are caused by the driver necking a couple of pints beforehand or fiddling with his or her phone as he's driving along, sometimes crashes are caused by unexpected black ice or a global pandemic running out into the middle of the road. So maybe they're not to be written off after all. The courts don't seem to mind the concept of LTAs at all. In one of the cases that involved the administration of Debenhams last year, we learned that the office holders were conducting an LTA with the intention that it would protect and retain value in the business, reduce new funding money requirements, maximize options for exiting the administration as a going concern. And they all sound like the kind of aims which are perfectly laudable. The courts are all in favour of rescue culture. They're all in favour of allowing administrators to have the kind of latitude that allows them to make judgments in the best interests of the administrator, of the administration. And of course, some of the commentary for all of those who've ever defended an administration's actions is pretty helpful, because courts won't interfere with administrators' decisions that are not made in bad faith, that are not clearly perverse. And I love this fantastically high hurdle. The administrator's actions have to be, in one of the cases, so utterly unreasonable and absurd that no reasonable man would have done it. Well, if an LTA is deemed by an administrator to be the way forward, then it's very unlikely to fall foul of any of that type of commentary there. But of course, there are some pretty big health warnings for an LTA, as you might imagine. First and foremost, the IP has to have a reasonable belief that the company can be rescued as a going concern. Otherwise, there's just no point to the LTA. And it sounds like something from the Ministry of the blindingly obvious, but you have to think about what the reasons for the company's struggle so far have been. Is it really just an unfortunate consequence of COVID or something else unexpected? Well, if not, then it might raise a few flags for the IP. And of course, it's not just where the company's been, it's where the company's going. You have to look ahead at the prospects for not just the business, but also its industry. For example, if you have a company which is in the business of events that relies on mass ticketing, it's not looking great for the next couple of years. And even if those type of events come back, they're going to have a much higher cost base. And so if you have an uncertain future for the industry, then you might want to think twice about allowing the same management team to remain in place, unless, of course, they come forward with a really robust transformation and change turnaround type of plan that gives you confidence that they'll be able to run it properly in the future as well. You've got to think about what involvement these directors are actually going to have. Are they going to be involved in debt collection, credit control, payroll and expenses, the type of stuff which is open to abuse? Is everything in place in terms of, say, GDPR and health and safety? What have the directors got to do with that? And I suppose part of the assessment for the IP is to say, have these directors just gone IP shopping? Have they gone round and tried to find someone who's prepared to let them back in to run the company? And if so, is that a problem? But it's not just for the IP to think carefully about whether an LTA is appropriate. There are a few things for the directors to consider as well, because even though those directors are going to have powers effectively delegated to them by the office holder, it doesn't take away from the fact that they are still directors and they still have statutory and fiduciary duties. Are they happy to retain those duties whilst not necessarily having control of the wheel? And of course, if you've got directors who founded the business and see it very much as their baby, are they going to be the kind of people who are going to follow instructions? Are they going to listen to some IP telling them how they ought to be running their business? The surefire way to make an LTA go completely wrong is to fail to set the boundaries from day one. What there is a very helpful draft consent protocol online, which has been produced by the Insolvency Lawyers Association and the City of London Law Society. I can make sure that we send copies to everyone who's registered for this webinar if it's going to be helpful to you. I think it's a really helpful base to work from because it sets out templates for things like what are the director's powers and obligations in relation to the company's property and bank accounts and so on. Are there limits on transaction sizes that they can enter into? Are there, for example, approved suppliers with whom they have to do business? But also importantly, it sets out things like the obligations on the directors to report. What are they reporting? How frequently are they reporting? How is it overseen? And then, of course, it's important to be able to have clear procedures in place for the IP to be able to either revoke or modify the consent that is given. So whether you choose to run an LTA or not, obviously depends on the circumstances of the job, but don't rule it out. It's coming back into fashion, and it's certainly something else to have in your armory alongside the ordinary choices of admin, liquidation or CVAs, each of which have their own costs and peculiarities associated with. Final thing to deal with, and I'm conscious of the time, I want to make sure Raghav gets enough time to do his talk properly as well, is out-of-court appointments, defective out-of-court appointments, the ongoing saga. Now, funnily enough, when you have three legislative schemes running side by side and overlapping with each other, there is sometimes the tendency for a bit of confusion to arise. And what we have going on at the same time in relation to CE filing and out-of-court appointments is we have the practice direction, we have the insolvency rules, and we also have one of many pilot schemes running, practice direction 51.0 of the CPR. And when you read those things together and try to find the middle pathway throughout all of those, the basic starting point was that if you have a notice of appointment which is filed at court by CE filing after the court's published opening hours, then on the face of it, that appointment doesn't take effect until the court building next opens up officially, which is usually 10 o'clock. So far, so simple. But for anyone who's been following this over the past year and a half, you'll see that that's exactly not how it's turned out. Because there were two cases that came out pretty much one after the other without, I don't think, referring to each other, which said totally different things. In S.J. Henderson & Co., ICC Judge Burton had a situation where there was an out-of-court appointment made outside of court hours. The IPs obviously wanted to fix that and regularise the position. And Judge Burton said, well, the curative provision at Rule 12.64, the one about formal defects being waived, can't actually help here because it's too fundamental a problem to overcome just by using 1264. So tough luck. But as I say, at pretty much the same time, in fairly similar circumstances, in a case called Skeggs Beef, Mr. Justice Marcus Smith, so he said the polar opposite. He said, actually, this is exactly the situation where Rule 12.64 can help. So clear as mud. I then had a case, pretty similar facts on all of this. We had an administration lodged at court at 5 p.m. and by 5:30, the administrators had pretty much sold the whole of the business. So it was problematic if it didn't in fact take effect until the following morning. This was a case called All Star Leisure, appeared in front of His Honour Judge Cook in Birmingham. And these were appointments that were made by the directors and the QFCH at the same time in relation to different group companies. We, of course, asked the court to follow the more permissive Skeggs Beef line of reasoning and allow the administration to take effect at an earlier time than 10 o'clock the next day. And His Honour Judge Cook, thankfully, was happy to follow that. So what we really needed was a hard-hitting, fully argued judgment from somebody laying down the law and saying, this is exactly where we are. But unfortunately, we didn't get that. We got a case called Carter Moore Solicitors, which followed later on. And actually, 12.64 was left to one side. This was Mr. Justice Snowden. And what had happened here, really unfortunate, solicitors for the directors filed a notice of appointment at court during court hours using CE filing, but they used the wrong drop-down box. So, of course, by the time someone at the court office noticed and sent it back to them, and they had the chance to rectify it, it was outside of court hours. That caused a problem. What Mr. Justice Snowden said was, you can forget about 12.64 for now, because in this case, the practice direction in the CPR 51.0 says that you can remedy an error of procedure which is made whilst using electronic working. So we'll just use that. And so he treated the original notice of appointment as the one which took effect, the one that was within the court hours. So it turned out fine in the end for them. But then what happened was another case, which was in front of Mr. Justice Zaccaroli, and this one was called Sim & Co. And the upshot of that was that he said, well, this out-of-hours scheme using electronic working, it's really only to preserve the power that qualifying floating charge holders had in the first place. It's never been for directors to be able to do things outside of hours. It's only for the benefit of the QFCHs. So that narrowed the scope a little bit. And finally, what we had, the Chancellor of the High Court took notice of the fact that nobody has a clue what was going on anymore, and lots of judges were being taken up to answer questions about whether or not administrations were valid or not. We had the temporary practice direction number 2. And what it said was that QFCH appointments out of hours must comply with Insolvency Rules 320 to 322. And that's a bit of an oddity, because those rules are supposed to be facilitating modern ways of working. And yet what it says is that if QFCHs want to appoint an administrator outside of hours, they have to send the NOA to either a specific email address or a specific fax number. And quite frankly, I don't know anyone who's still got a fax machine. So I don't know why that rule has remained in place, but there we are. So it narrowed it down, and the position, if anyone's followed that, by the way, well done. But what I've tried to do is narrow down those cases and come to a position where I think we are, which is that if you are a director making an appointment of administrators, then that administration takes effect during court hours. If you make an error of procedure, like we saw in Carter Moore with the wrong drop-down box, you might be able to rely on practice direction 51.0 in the same way that Mr. Justice Snowden did. But out of hours filings are referred to a High Court judge to review and determine whether or not the appointment is valid, and if so, at what time. So if you're making appointments on behalf of directors, get it in during court hours, because otherwise you're going to find yourself in trouble. If you're for a QFCH, an out-of-hours appointment can take effect at any time, so long as you comply with those rules 320 to 322, so the specific email address or the fax number. But if it goes wrong, you might actually still be able to rely on where we started, which is rule 12.64, relying on that Skeggs Beef line of reasoning, which is to say, actually, that's a rule which still has some application in the right circumstances, if you can show that really it's no harm done just because we made an error. There's a final question which people sometimes forget during these cases to deal with. What actually are the court hours? Sounds an obvious question, but it has caused confusion over the time. 10 o'clock to 4 o'clock, Monday to Friday, no exceptions. So I hope that clarifies things a little bit. What I'm going to do is I'm going to stop sharing my screen. I'm going to hand over to Raghav, who's going to be talking to you about recent cases on directors' liability. If you've got any questions, please pop them in the Q&A, and I may be able to come back to them at the end of this. But otherwise, thank you for sticking with it.
Thank you very much, Ali. I'll just share my screen. There we go. Hopefully we can see that all on the screen there. So thank you very much, Ali, for that wonderful talk. I'll be talking about recent cases on directors' liability following on from that. Naturally, this could encompass a wide-ranging number of topics, but obviously, given the limitations of time, I've chosen 3 cases, 2 of which I shall go into in a bit more detail than the third. So I'll just move the screen. The first is the matter of Bright Future Software Limited. And as you can see, yes, we're returning back to the age-old Section 214 provision for wrongful trading. Now, as of 7 p.m. yesterday, I believe the suspension of wrongful trading has now been extended to the end of June, to my slight mini panic. But nonetheless, I still feel it's important that we do turn our attention back to the wrongful trading provisions as we slowly approach levels of normality in this pandemic that we face. Indeed, in any event, whilst the suspension is in place, the wrongful trading provision isn't totally inactive. And if you have a look at Section 12 of SIGA 2020, you'll see that there are a number of accepted companies where the provision still applies. The aim isn't to go into Section 12 of SIGA, it's only to look into Section 214 and provide a refresher on the wrongful trading provisions. And indeed, the matter of Bright Future Software was the only wrongful trading case that's been decided since the first lockdown. I'll then turn my attention to the matter of Atkinson and Kingsley. And as I've put on the screen, duties of directors at war. And the reason for that is this case dealt with the fiduciary duties of a director in the context of the actions of a co-director. And then finally, I'll briefly touch upon, in a simple manner, the matter of SHAHI Tandoori restaurant, which looks at the evidencing of losses in a misfeasance claim and the importance for an office holder to evidence those losses. So turning to the matter of Bright Future Software Limited. So in a nutshell, Bright Future Software, which I'll call BFS, was a software developer, provider, a trainer, and Mr. Ellis was a non-executive director of the company and a minority shareholder. And Ms. Thompson was a majority shareholder and a director of the company. Mr. Ellis had been providing substantial funding to that company, but unfortunately, BFS was a loss-making entity and entered into CVL in 2016. The liquidators identified a number of claims against Mr. Ellis, and that was assigned across to a litigation funder specializing in insolvency matters. And the funder brought claims for wrongful trading, transactions at undervalue, preferences, and breach of duty. The largest claim was for wrongful trading in and around the sum of $6.5 million. Now, you'll be aware that wrongful trading is essentially a statutory offence against a director. And principally, the provision we need to concern ourselves with is Section 214. This applies where the director knows or ought to know there is no reasonable prospect of avoiding an insolvency process, and that director does not take every step with a view to minimizing potential losses to creditors. That is, they're simply allowing the the company to trade beyond the point of an insolvency process and really damaging the company. There's an objective and subjective element to the test that the court does apply, and that's at Section 2144 of the Insolvency Act, which states that the facts which a director of a company ought to know or ascertain, the conclusions which he ought to reach, and the steps which he ought to take are those which would be known or ascertained or reached or taken by a reasonably diligent person, having both the general knowledge, skill, and experience that may reasonably be expected of a person carrying out the same functions as are carried out by the director. So that's the objective part of the test, and the general knowledge, skill, and experience that the director has, i.e. the subjective element. In this case, the loss of $6.5 million represented the increase in the net deficiency of the company's assets between the point at which the company ought to have stopped trading and when it in fact did stop trading. And as a reminder, that's the test that the court will apply in determining the loss that the company has suffered. What is the net deficiency in the company's assets? Similar to looking at insolvency generally from a balance sheet insolvency perspective. The argument from the funders was that Mr. Ellis should have known or knew by the time the company ought to stop trading that BFS was balance sheet insolvent, its position was worsening, the sales were inadequate, and there simply wasn't enough funding available to keep the business going. However, in this case, the judge did not find Mr. Ellis liable. And a key point for this, as I put out on the screen, was the role of professional advisors. It was found that these external professional advisors had not alerted the director to the true financial position of the company when things started to go south in and around 2015. And in a bit more detail, the court said that it was very harsh if the respondent was held liable for wrongful trading when he had not been irresponsible, hadn't closed his eyes to the reality of the company's position or allowed it to carry on trading. And on the contrary, his understanding of everything that was going on and everything that he was being told was that it was very positive. And the basis of this was the input from those external parties. The judge found that the director had not turned a blind optimism, and he had not based his belief on something which was reckless. And actually that he held a belief which was rational based on what he had been told. So what can we take away from this? Well, firstly, the two-part test that I alluded to earlier, the objective and subjective element, clearly shows that the wrongful trading provision is a challenging provision for an office holder to bring. It's not the easiest one to satisfy, as shown by the facts of this case. Here we find a director who had taken advice and based his belief on that advice. And despite the fact that he did still allow the company to wrongfully trade in that period, he was found to have not breached that provision. However, in the alternative, it may be more appropriate, therefore, to consider an action for a breach of duty or plead that as an alternative. Secondly, the importance of advice being given to directors as early as possible to consider whether professional advisors have protected their position. And thirdly, and most importantly, the court went on to consider the pleading of dates, i.e. the date of which the director knew or ought to have known that there was no reasonable prospect of avoiding an insolvency process. In this particular case, the judge had stated that the date relied upon by the applicant was the date that the respondent should have known that there was no reasonable prospect of the company avoiding an insolvent liquidation. And that actually, whilst the case law isn't very clear on the point as to whether we need to plead the specific date as an office holder, the judge stated in this case that the court can, in certain circumstances, based on the material available to it and as disclosed to the other side, consider the date that's appropriate in the circumstances. So the advice there, or the key takeaway point is, whilst it is important to plead your dates properly, to make sure that the director knows what case it has to meet, the important point there is, if that has not been done, or there is an argument for more than one date, the court may take this into account. Of course, for an office holder, that can be tricky, even for, of course, an assignee of these claims, because you may not know what that date is. So it's important to hold an interview with these directors and conduct a fact-gathering exercise as early as possible in order to determine what that date is, or as I've said, plead breach of duty, which provides a cushion for the office holder in the alternative. The court then went on to consider the question of the litigation funders. And this is a side point here because the court really didn't answer the question. There was a concern that the litigation funders had brought this claim for £5,000. And of course, with a £6.5 million claim, they sought to make a large recovery from the proceeds. The judge acknowledged the concerns, but had said nothing in relation to it because it did not concern the matters in issue. So do watch this space, because the role of litigation funders, as they always do, plays some role in claims of this nature, and to see whether it would be unconscionable or unjust for them to bring claims of this nature when they're due to make a large profit from it will be a question which the courts may consider in the future. The second case is the matter of Atkinson and Kingsley, which is a breach of duty case. Here we have a property development and letting company owned by two individuals. The company's only two directors. In 2010, the relationship between the directors started to break down, and by the middle of 2010, due to a reduction in the income for the company, it was going towards a future loss-making position. The directors agreed to wind the company's activities down and distribute the profits between themselves by way of a dividend. One of the directors instructed a payment from the company's bank account by way of a banker's draft to a third party without the knowledge of the second director at a time when the company was clearly heading towards an insolvency. The unknowing director therefore froze the bank accounts until the bank mandate was changed to require the signature of both. Clearly, by this point, the relationship between the directors was worsening. The company went from administration to liquidation in 2012, and the liquidators brought a claim against the two directors to recover this payment. It only pursued the unknowing director, the one that didn't know that the other co-director had accessed the bank account, because the other co-director had become bankrupt. The liquidators sought the unknowing director to reimburse the company. Now, the liquidators argued that the relationship between the directors had broken down so badly that the unknowing director ought to have put arrangements in place to prevent the other director from dealing with the company assets without her authority. So essentially, the liquidators relying upon Section 172 of the Companies Act 2006, i.e. to promote the success of the company, with also Section 174, the duty to exercise reasonable care, skill, and diligence. The court set out the test to be applied for breach of duty. That again, similar to wrongful trading, there's a subjective and objective element. Had the director, in this case, honestly believed that by not restricting access to the company's account, that was in the interest of the company, well, that question had not been considered by the director at all. So that subjective element had not been satisfied. She had not turned her thoughts to that question. So then the court moved on to the second part, the objective element of the test. Would an honest and intelligent person in the position of the director have left the other director in the position of trust with unfettered access to the company's accounts? I.e., whether an intelligent and honest director of the company could, in those circumstances, have anticipated that steps would need to be implemented before the other director made the payment to prevent the director from having unrestricted access to the company's accounts. The judge made clear that the liquidators relied too heavily on hindsight, and that's the key takeaway from this case. The focus should be on the evidence, placing the director in the position that they were at the time when these events occurred, not looking back at what the director ought to have done from the standpoint of today. Were the battles between the directors at that time enough to warrant the seizing of the company's accounts? In this case, the court found no. The director who had access to the accounts had never done this sort of thing before. The court found that even if there had been a breach, I believe it was Section 1157 of the Companies Act that was applied, the judge stated the director should be excused as being an honest director in relation to that payment. The director had not benefited from it, and the moment she found out about the co-director accessing the accounts, she took actions to prevent this. The key takeaway there as well is that, as I put out on the screen, is that honesty does prevail, but the objective standard should not be forgotten. Because if a director does not take into account what has happened at that time, then the objective standard will come into play. Finally, the court considered that the company was at a loss-making position. So it's important for directors to be, or those advising directors to be aware of the potential risks of misfeasance by co-directors. And it's important to advise directors by applying the above test to really understand whether a director should take some form of action against a co-director or whether to take any action at all. That really would be a fact-by-fact analysis. And as I've put out on the screen, should that co-director respect the boundaries of the other director, or should some form of action be taken to protect that director's position to avoid any breach of duty claim arising? And the final point is really the matter of SHAHI Tandoori restaurant. And I only touch upon this very briefly. The facts of which aren't too relevant, But nonetheless, it's the most recent case which dealt with misfeasance and the important point of evidencing your losses. So in a nutshell here, HMRC had raised an assessment against the company for under declarations in VAT returns, and the liquidator brought a claim against the directors for misfeasance under section 212 for the repayment of large sums based on HMRC's assessment of the missing VAT. The judge in this case stated that it was wrong in principle to base the remedy on HMRC's findings. The liquidator was seeking equitable compensation. That's not what HMRC had sought. And indeed, some of the cash taken by the directors in this company was used for the company's benefit. The company had actually been successful in some of the years, more than others. And what the court found was that it was important to take into account. So it's important that as an office holder, you do not piggyback off the evidence of other, in this case, HMRC, other external organizations, the basis upon which you're bringing your misfeasance claim, to really hone down into what is the loss that you're trying to recover. And in this case, if it's equitable compensation, is to really focus upon what that really means. But however, there is some respite for the office holder, because the court found in this case that if a respondent, for example, was failing to produce company documents or records which would really assist in evidencing the loss, the court may be constrained as to what it can do. So then it will try and arrive at the best figure it can in the circumstances and utilize whatever evidence is available. Here, of course, the HMRC's evidence was available, but the words used by the judge, quite importantly, was the best, swiftest, and cheapest evidence. That's not to say that one shouldn't evidence their loss from the outset and do their best they can in that respect, but there is that backup position that the court will determine the position one way or the other. But of course, one doesn't want to rely on the whims of the court to that extent. Further, the key takeaway here as well is that when the importance of evidencing your losses is backed up by the fact that there may be an additional delay in cost if you haven't. In this case, the court, in its discretion, decided to take an account that had not been something which had been pleaded. So whilst it's established that the directors had caused the loss to the company through the misfeasance, the evidence was simply not enough to enable the court to quantify that loss, and that's why the account needed to be taken. So that again shows the importance of making sure that office holders produce the best evidence possible. So as you can see, that's a very whistle-stop tour through all those three cases. If you do have any questions for me, please feel free to ask in the chat function. My email address is on screen as well. I pass you back over to Ali, and I'm sure will have a few questions that he'll answer, and then I will also answer after him. Thank you.
Well, Ali, three questions from you, one on each of the three topics that you covered. Can we start with pre-pack sales and qualifying reports? What would be a good reason for an administrator departing from the opinion in a qualifying report?
Well, probably nothing different to how it was before, which perhaps highlights some of the absurdity about this rule. There's nothing in the guidance, there's nothing in the regulations, sorry, no guidance to go with the regulations that tells you what actually the administrator needs to say to justify departing from a negative opinion. So presumably it just goes back to the same old case law that we looked at in the slides, which is that as long as the administrator isn't acting so unreasonably that no other person would do it, etc., then they'll be fine. And you come full circle and say, well, wasn't that already the position, except without all of these expensive and time-consuming additional rules? It was always the case that the administrator had to take decisions that were rational. It's absolutely no different now. So basically, as you were.
Not something to be particularly nervous about then?
I don't think so. I think often in pre-pack connected party sales, they are the only viable purchaser, or they're the only purchaser who can get things through quickly to actually save the business as a going concern or save jobs. It's a good enough reason by itself, I'd say. Doesn't need to be very long.
Let's move on to light touch administration. Goodness, this is a tricky question for you. What happens in a light touch administration if an administrator asks a director to do something that the director considers would be in breach of their director's duties?
Yeah, it's a really tricky one, and that's one of the kind of major issues for directors going into this, because as I said in the talk, they've still got their statutory, common law, fiduciary duties towards the company. If they genuinely think that they're acting in breach by following what the administrator tells them, then there's absolutely no excuse for them to do it and then say, but they made me do it. At the end of the day, they are still a director. They still have the duty to resign or get themselves out of it or act contrary to that situation. LTAs are generally only going to work if you have quite a high level of trust between the parties. And that's where having those frank discussions about boundaries and so on before you start is really important, because they're going to need to genuinely be working together rather than against each other. And if you ever get to a situation where the administrator is getting the director to do something that they think is not in the best interest of the company, it probably tells you it's a failure of process at the beginning.
Thank you. Then finally, defective appointments. You're asked, aren't London opening hours 10 until 4:30?
They are, but the Temporary Practice Direction number 2 sets it out at paragraph 3.3. It says that it's 10 till 4. Even though, as we know, if you send it into London at 4:29, as one of our attendees has already pointed out, they'll probably still process it for you on the day. Best to be safe, keep it at 4 o'clock. The difference between London being 4:30 and everywhere else being 4 was exactly the problem that we had in the case that I did in front of Judge Cook, the All-Star Leisure one. We sent it in at something like 4:17, assuming it would be dealt with. Why it makes a difference, I don't know, but long and the short of it, stick to 4 o'clock.
4 o'clock. Thank you, Ali. Raghav, can I ask you a question arising out of the Bright Future Software case that you discussed? Does it make much difference that we haven't had liability for wrongful trading for the last year or so? Can you just reframe a wrongful trading case as a breach of director's duty case?
In my view, you can. Breach of duty, I would have thought, is the preferable claim to bring. Wrongful trading, as I said, it's a more of a challenging claim, but they both have similarities, particularly when you consider Section 174 of the Companies Act. The test is very similar, as I set out in my webinar. There's an objective element to the test and a subjective element. So you determine what the director ought to have done and what the director did in the circumstances that the director found themselves in. So to that extent, it doesn't materially matter which type of claim you bring. And indeed, there are a number of procedural requirements for wrongful trading that differ to breach of fiduciary duty. So it might be easier for an office holder to bring the former. Having said that, they usually are pleaded in the alternative anyway, so that would be the position there.
Wonderful. Thank you, Ali. Thank you, Raghav, for your talks today. Thank you for the questions that have come in on the Q&A. Thank you, everybody, for watching. This talk and all the talks this week will be available on the YouTube channel in case you missed any or in case any of your colleagues might want to watch them. I hope you can join us for our panel discussion tomorrow. In the meantime, enjoy the rest of your day.